Welcome to Probate 101. Class is now in session. My name is Cyrus Malhotra with the Malhotra Law Firm. We're a Florida law firm with offices throughout the state. Join me today as I answer the question, is probate required when there's a will? Stay tuned. Many people think that if a decedent or someone who passed away left a will, that probate is not necessary. This is simply not the case. Probate is the court-supervised process of transferring assets from someone who's passed away to their rightful heirs, governed by Florida statutes 731 through 735. The wishes of a will are overseen by a judge in probate court. Estates that have a will are known as testate estates. It's also very common for a prospective client to tell me, I don't understand why the bank won't speak with me. I've shown them the will and I'm named as the personal representative. This is incorrect. The will merely nominates you as the personal representative. Before you are actually appointed as a personal representative, we must first determine if the will is in fact valid. There's only one class of person who can validate a will, and that's a probate judge. Even I, as an attorney, cannot validate a will. I can merely give you my legal opinion on whether I think the will is valid. Once a will has been determined to be valid, we then move to the next step. In order to have a valid will, the will must be in writing, the will must be signed by the testator or another person at the direction of and in the presence of the testator. The will must be signed at the end, in the presence of at least 2 attesting witnesses, and the witnesses must sign in the presence of the testator and one another. We also look for a self-proving affidavit, which is a statement that verifies the authenticity of an individual's last will and testament. The affidavit affirms that the testator, the individual who created the will, executed the will voluntarily, and they did so in the presence of 2 witnesses. This document is notarized. If the will is determined to be valid, then the terms of the will are enforced in most circumstances. Therefore, if the decedent passed away and left 4 children and leaves $1 million to Aunt Lucy gets the $1 million, not the children. Exceptions to this include fraud, duress, and undue influence, just to name a few. Also, spouses have certain rights even if omitted from the will. The Malhotra Law Firm has processed thousands of testate estates throughout the state of Florida. If you have any probate-related question, please call us toll-free at 877-WE-PROBATE or visit us online at 877weprobate.com. I'm Cyrus Malhotra with the Malhotra Law Firm. Class is dismissed.